If you have a case that's headed to trial and you want to know what you need to do or what to expect, this is the video you need to watch. So stay tuned. Hi, I'm Michael Coker, a local personal injury lawyer in Lawrenceville, Georgia. And one thing that makes me different from many personal injury lawyers is that I actually do trials and try cases. And so I'm going to talk to you a little bit about a trial, what to expect, what the process is, and what your lawyer might not tell you for your case. So when you go to a trial, it's going to depend on whether or not it's a jury trial or a bench trial. Now, a jury trial means that there's people that are just like you, your peers, who are sitting and making a decision in your case. The bench trial is when a judge makes the decision. And the case is different based on the type of trial that it is. Now, if your case is a bench trial, don't expect there to be big inflammatory arguments or big visuals that would normally be used in a jury. Judges hear cases all day, every day, and you are going to get a better result if your lawyer is succinct and short and basically is very efficient in how they present their evidence. With a jury trial, juries in the post-CSI era like to see more theatrics, more visuals, more testing, more objections. And so you might get a little bit more of that, a little more heated in some of the arguments, for example. But we're going to talk a little bit about the process. And the process is really the same for both types of cases. So obviously if you have a jury, you have jury selection. We'll talk about that in another video. But we're going to talk about the actual process of the trial, where what happens is both the same for both a jury as well as for a bench trial. And so when you start a trial, the first thing that happens after jury selection is what's called an opening statement. And that's where your lawyer stands up and says, "This is what I expect the evidence to show in the case." Now, in many jurisdictions, the lawyer's really not supposed to argue the case at that point. They're just supposed to give an outline of what the evidence will be. Now, in most jury trials, again, many good lawyers will ultimately, throw in a little bit of argument here or there just to kind of stir the pot or get the jury to understand what ultimately will happen as far as the legal arguments in the case. But the rules state that it's just supposed to be a presentation of evidence. And so they're just going to start at the top, say this is what happened, this is what's going to happen in the trial, and this is what you can expect. After the opening statement, then the plaintiff, if it's a civil case, will start calling witnesses, or this would be the prosecution in a criminal case. And this is exactly what you see on TV. Individual witnesses come up to the witness stand, they raise their right hand, they swear to tell the truth, the whole truth, and nothing but the truth, and then they provide whatever evidence or facts that they know that are relevant to that particular case. And so you'll have these witnesses that'll come up, they will testify, maybe one at a time, and they'll be called up by each party individually, and then they will be asked questions to determine what facts that they have that the jury's allowed to hear that will help the jury or the judge make their decision. Now, the other thing that happens in this phase is the parties will admit exhibits or documents or videos or photographs that are relevant and admissible regarding the case. And so during this process, you might have a witness who maybe took photographs of a car accident, for example. You'll ask that witness, is this the photograph you took? Yes. Is it a fair and accurate depiction of the photograph that you took? Yes. Judge, I'd like to admit this as exhibit number 1, for example. And so that would then be admitted. The jury would then be allowed to see that document and would also be allowed to review that document when they go back for their deliberations. Now, first the plaintiff will call all their witnesses and admit all their documents. Then the defendant will call all their witnesses and admit all their documents. And then sometimes the plaintiff or the prosecution has the opportunity to rebut and to call any rebuttal witnesses in the particular case. Once that's done, then both sides will give what's called a closing argument. And this is where the attorney takes the evidence or the facts that were presented and applies them to the law and tells the jury why they need to find or come up with a certain decision over another. Closing arguments typically can run anywhere from 20 minutes to an hour, depending on the complexity of the case. Sometimes they're even longer on really complex cases. And every jurisdiction has different rules as to how long both your opening and your closing can be. But it's basically an opportunity for both sides to say what they believe that the evidence showed and how it applies to the law. Now, very important, the attorneys don't actually tell the jurors what the law is. Only the judge is allowed to do that. And that comes after after closing statement, where the judge will ultimately read what the law is that applies to the case. Now, during closing arguments, the individual attorneys will argue what the evidence showed and how it applies to the law. Now, the jury will typically only hear the law from the judge. Him or her will read the law after the closing arguments. But in most cases, the lawyers have a copy of that law ahead of time. And so they're able to kind of show the jury or kind of argue how the facts apply to the law, even though the judge hasn't read it. Once the closing arguments are over, the judge will then read the law. These are called the jury charges, and it's the law that applies to this particular type of case. Once the jury reads the law, then the jury will then take those exhibits and will go back and start their deliberations to make a decision. Now, if it's a bench trial, obviously the judge is not going to read the law to himself. The judge himself or herself is going to know what the law is. And then sometimes they'll make a decision right then and there, and sometimes they will take the matter under what's called advisement. That means is that the judge will ultimately think about it for a couple days, maybe do a little more research about the law, and then we'll get back to the parties with their final decision. So don't be alarmed if you have a judge that says they want to take a case under advisement, and you don't actually get a decision in your case for a week or 2 weeks or however long it may take. That's just a sign of a judge who really wants to focus and make sure that they understand the law before they make a decision. And so that's kind of a basic rundown of what a trial is and the process as you go through. There's a couple other motions that may happen. Motions are basically legal arguments or requests that one party or another may have in the case. Sometimes those motions happen before the trial. Sometimes they happen during the trial, sometimes they happen after the trial. But as you can see, a trial is extremely complicated. And so this is not something that you want to try to handle on your own. I never recommend that any individual step in a courtroom without a lawyer. Lawyers spend years and years, not only in law school, but training after they get out of law school to understand lawsuits, trials, and how they function. But also to anticipate changes, right? I mean, if a judge ultimately decides, let's say early on in the case, that a certain piece of evidence is not allowed to come in or the jury can't hear about it, well, guess what? Now you have to completely pivot and change your entire structure, your entire plan last minute based on that judge's ruling. So a good lawyer will anticipate and will kind of have 3 to 4 to 5 different options of what they may argue or how they may present the case based on what the judge ultimately decides early on. And so definitely talk to a lawyer, definitely talk to somebody experienced who understands these cases and who knows what they're doing so that your case is protected and you have the best chance of winning your case in court. So if you have a question or if I can help you, obviously reach out to me. I'm more than happy to discuss it, but just reach out to a local attorney in your jurisdiction, somebody who's local, maybe has an office in your town, maybe understands these type of cases. You can tell that maybe they're an expert in these kind of cases. And be sure that you get a good quality legal opinion before you ever try to handle a trial on your own. If you like getting these updates and kind of learning more about the law in Georgia and kind of how things work, obviously like and subscribe. But thank you for listening, and we will see you next time.